Defendant Daisy Link is charged with second-degree murder for allegedly shooting and killing her on-again, off-again boyfriend, Pedro Jimenez, on June 25th of 2022. Prosecutors believe that Link was the aggressor in the relationship, but her defense claims that she had been trying to leave Jimenez because he was, quote, out of control, unhinged, and dangerous. Let's get you back inside of that courtroom. The jury is not present, but the judge is on the bench.
But it is being redacted.
Yes, ma'am.
How are you all going to redact it in time?
We're doing it right now.
So what?
Are you able to do it from there?
No, Judge, but we're not saying.
It's going to take some time anyway for me to get to the point in time with Detective Jean, so we can figure that part out. And then I did inform Mr. Tomas there's a jail call that a portion of it I intend to introduce. It is entirely relevant to phase 2. The entirety of that call, it kind of talks about the prior convictions in that call.
What do you mean phase 2?
Should the defendant be found guilty, we would then do a enhancement portion of this. As noted, the state filed its notice of enhanced penalties. In this case, which the jury will have to make the determination whether or not the defendant is a habitual offender. This call is entirely relevant to that because she talks about her prior convictions. The portion that I want to elicit in testimony during Detective Janor's testimony is a portion of time in which the defendant, there's conversations about what essentially she is facing, that there was a conversation about 15 years, and she says the prosecutors changed their mind and they said no, 25 years. The defendant says, well, if I would have known that, all around for it.
Let's just focus right now. Why would I let the jury hear that she admits to her priors?
No, I'm not introducing that portion. Like I said, the only portion that I'm intending to introduce for this portion of the testimony is what I just said. If I knew how much time I was facing, I would have done this. The reason that I want to introduce that is because, number one, it goes directly to her intent and will directly refute the statement that I'm about to introduce as well, that this was a mistake, that this was a misunderstanding, that she was protecting herself. This goes directly to that, and specifically elements 3, I think, of this crime that the depraved mind that goes directly to this.
That's on the jail call?
Yes.
Okay, what's your response?
So, Judge, this jail, I don't know exactly when it was, but it's my understanding that it was, what, in the last month?
Last couple of weeks.
Last couple of weeks. So we've got that, a lot of time has passed. She's talking about what she's facing. So, first of all, this conversation, this very small part of a 15, 20-minute conversation, I would submit that it's far more prejudicial than probative. I don't think it's probative of anything, but if the court were to allow it, then it opens up, or it opens the door for her to explain her state of mind and why she said it. And if you do that, then we're talking about, well, facing life. This other guy got 25 and he was charged with a lot more.
I don't have an objection to that.
Said that in jest, things of that nature. So I think it just opens up. It opens up for a lot of problematic issues.
I don't have an objection to her talking about that. About the time that she's facing and the state of mind in which she said.
You don't have a problem?
I have zero problem.
I have a huge problem with that.
Judge, there's no pending.
When I use the word duty in front of the jury, why did I go through that? And I use that very diplomatic, neutral word instead of prison, minimum mandatories, enhancement.
We talked about that during voir dire, that they would not be a part of the sentencing phase. Your Honor brought it up. I brought it up. I forget the gentleman who mentioned that something about how he would be uncomfortable sitting in judgment of it because he could potentially be taking somebody's life away. And then we discussed that this was not a capital case, that she is not facing the death penalty.
So why would I now allow them to hear that she's potentially facing
Judge, I'm not making, nobody has made a motion in limine to limit that portion of this case. Normally, the state brings that up in a motion in limine because it is inflaming the passions of the jury to say, well, this woman's life is in your hand, and if you convict her, she's facing this. I do not have a problem, and I am not making a motion in limine to limit that. I don't think that it would be a compelling closing argument to make, but regardless of that, this call is, number one, a business record. Number two, it is the defendant's statement, so it's not being introduced for the truth of the matter asserted, for a statement by party opponent as well as a business record, so it's admissible as such. And then number two, the reason that it's more probative than prejudicial is because, again, element 3 of this crime is that the defendant committed this act with a depraved mind, which goes directly to this case. The defense's argument, theory of the case, I'm introducing her statement in which she says this is self-defense. Mr. Tomas, during a number of different testimonies, has elicited the testimony, especially with Dr. Mathis, about how the victim was charging at the defendant, screaming at the top of his lungs. I think during opening statement, he said this was a guttural, vicious, almost demonic statement that the victim made, which Ms. Link, in this jail call, in this portion of the jail call, and it's about 30 seconds, says, well, if I knew how much time I was facing, I would have chopped him up and spread him all around Florida. The reason why that's so important is because she says this was an accident. She didn't mean to do this. This wasn't her intention. This goes directly to that and the depravity of her mind at the point in time that this crime was committed. I have zero problem with Ms. Link when she testifies, because I think we're all on the same page here that she is going to be testifying. I have zero problem with her explaining that call, and she should.
Okay, your request is denied. It is highly inflammatory, highly irrelevant. It happened 3 years after she was arrested. The context of which she's making that statement is during a breakdown of plea negotiations. It's also not connected in any way temporally to the commission of the crime or any statements she made post-Miranda.
Well, Judge,
it's also more, pleadings are closed, no more argument. You started first, you went second, you're going third, and that's it. It's also more prejudicial than probative. That's my ruling.
I understand your ruling. I just want to put two things on the record. Number one, during the court's ruling right now, I can see it on the computer screen. Ms. Link is rolling her eyes every time I open my mouth. I would ask the court to admonish Ms. Link once again. I know that we had a conversation sidebar about that in the next of kin. I think that this is becoming a feature of what Ms. Link is doing during this trial and trying to, get her 15 minutes of fame. And number two, I think this goes directly to the defendant's consciousness of guilt, of what she would have done.
Thank you. You have asked, sir. Ms. Link, I cannot go in the mind of the jury. I think they're paying attention. I think they're dedicated. The fact that they're here early almost every day and they come back for lunch, we've been doing the case, not them. You're not allowed to make any facial expressions. Like I said before, this is a tragedy all around. You're allowed to be emotional. You have to control it. Because I literally told the next of kin, through Mr. Burita, that I could see their emotions, and I asked him to have them limit their emotions. It was cumulative over a few-day period. I haven't been looking at you. I don't know if you're rolling your eyes or anything of that nature. I know that you got emotional when the body-worn camera was played. Just about everyone did. But the jury needs to decide this case based on the evidence and not from any outside influence. It's actually in your best interest to control any facial expressions you may be doing, because if they don't like what they're seeing and they don't tell me, I don't know what's in their heart, and I don't know what's in their mind. Does that make sense?
Yes, it does.
Okay.
So just the only other thing that I wanted to inquire about is the order that you were able to get a certified copy of. Can I use that, or do we need to get like an original from the...
I don't have an objection to the introduction. I still think that the court needs to take judicial notice that a termination of parental rights does not exist in this
You have
case.
an objection to me doing that? I think I was inclined to do that.
That's fine, and I would seek to admit that order as a certified document.
It's interesting that the prosecutor raised this outside the presence of the jury, which is the proper thing to do, but rather that the judge then, in spite of it not being in front of a jury, said, stop rolling your eyes. You have to control your facial expressions. It's disrespectful to the next of kin.